Think of this as Business Escrows 101. Hi, this is Tony Cordy of the Innate Group. Today we're going to take a look at the escrow process. I know it can be daunting, but I think I can help you through it if we're prepared. We know what to look out for. It's worth it. It's a great thing to have working for you. You don't want to take on anybody else's liabilities. I know that's one of the biggest concerns, but we can make this happen. So join me while we talk about the escrows and how to get through them. The simplest way to think of an escrow is as a process. And at the end of the day, we're talking about having an escrow service or escrow company working on behalf of a buyer and a seller on holding funds in an escrow until such time when all conditions of the escrow have been met and the proceeds from the escrow can be distributed. Once you've selected who the escrow holder will be, and this needs to be a mutually agreed upon decision between the buyer and seller, then opening the escrow is a fairly straightforward matter. The business purchase agreement will be submitted to the escrow holder, and then typically the escrow holder will request certain contact and other general information from the respective parties. Once the escrow holder has all of this information, he or she will create a draft set of escrow instructions that hopefully clearly define all of the contingencies of the agreement. In other words, what conditions will need to be satisfied before the escrow can in fact be closed. The escrow instructions are a critical part of this escrow process, so it's very important that both parties are in agreement with the contingencies or conditions that have to be met before the escrow can close, what happens in the event of any form of dispute, and what happens if outside of the contingency periods one or the other party wishes to cancel the escrow. These are all important things that need to be spelled out in this stage of the escrow, the drafting or creation of the escrow instructions. It cannot be overstated how important the contingencies are. Both sides of the transaction, the buyer and the seller, have to be in agreement with the conditions of these contingencies, timing, etc. It's very critical that everything be clearly spelled out at this phase. One of the biggest concerns about buying a business, especially for first-time buyers, is the concern of taking on any of the seller's obligations. It's the fear of the unknown, not knowing what's out there, and the escrow process is a great clearinghouse for liens and any other claims from creditors, etc. So we really want to embrace the escrow process. In my experience, the number one concern of buyers is that they're not inheriting any of the surprises, the debts or obligations, the skeletons in the closet, if you will, of the seller. To this end, the escrow holder does a few things. One is have a lien search conducted to make sure there are no liens, or if there are, identify them so that they can be dealt with through the escrow process. Number two, to publish what's called a bulk sale transfer notice so that creditors have an opportunity to put their claims into the escrow for those particular assets if they have obligations that are due them from the seller. And then the third thing, which we'll talk about in a little bit, is the escrow holder will get clearances, tax clearances in particular, from the EDD, the Employment Development Department, the BOE, the Board of Equalization, and oftentimes, but not necessarily all the time, the Franchise Tax Board. As a buyer, you want to be certain that you get clearances through the escrow process for each of the three primary government agencies, namely the Employment Development Department, or EDD, the Board of Equalization, and the Franchise Tax Board. And the primary reason for this is that they have what is considered to be successor liability laws. They have the possible reach in the event of a default of the seller to go after, under certain conditions, the buyer. So we want to make certain that we have clearances from these three agencies. When all the contingencies are removed, the escrow holder will start to develop the settlement sheets, which will delineate all the costs associated with the escrow for both sides. These settlement sheets need to be signed off and agreed to before the escrow finally closes. On occasion, there might be some charges that the seller did not anticipate, perhaps in the form of liens or creditor claims The seller will have an opportunity at this point to dispute those charges. However, the escrow holder may reserve the right to hold back the money in the escrow. So escrow may be able to close, but the money may not get distributed until the dispute is resolved. So that's it for the escrow process. Think of it as Business Escrow 101. Okay, so I hope our review of the escrow process was helpful. Next time I'm going to break down the purchase agreement process, the actual steps to go in, putting together an offer, and what comes up, how you're protected, and so on. So that'll be for next time. Thanks so much for watching.